Legal and Privacy Brief for February 26, 2026. European DPAs issued 3 enforcement actions for GDPR violations, including a Euros 2,000 fine against a Romanian dental clinic for failing to cooperate during a data breach investigation. Federal courts are establishing new precedent on the discoverability of AI-generated content, with attorney-written prompts receiving work product protection, while client and employee prompts remain discoverable. Estonia's DPA ordered a media publisher to remove identifying information from news articles citing diminished public interest and excessive harm to the data subject. Here's the full breakdown of today's top legal and privacy stories. Legal and Privacy Brief, February 26, 2026. Next section, Enforcement Actions. ANSPT, Romania, 20.02.2026 Romania's DPA ANSPT. Fined SC Hayat Dent SRL Euros 2000, RON 10,190, for violating Article 83.5 GDPR by failing to cooperate during a data breach investigation. The case originated when the dental clinic reported that a former employee copied the contact details and medical records of all patients to solicit appointments at a competing clinic. The controller failed to respond to the DPA's information requests after an initial warning and compliance order. Compliance action. Organizations must maintain incident response procedures that include timely cooperation with DPA investigations. Failure to respond to supervisory authority requests is itself a GDPR violation subject to fines regardless of the underlying breach circumstances. Source: GDP Rub 20.02, 2026. ECI Estonia 2. 1-1/24/1246-3074-22 Estonia's DPA. ECI ordered media publisher Delfi Media as to remove photographs and replace full names with initials in news articles under Article 17 GDPR after finding excessive harm to the data subject and diminished public interest over time. The publisher had refused the erasure request and offered only de-indexing as an alternative. The DPA set a compliance deadline of October 27, 2025, with penalty payments of Euros 200 per violation for noncompliance. Compliance action. Media organizations processing personal data in archived content must periodically reassess whether the public interest justifies continued processing as time passes. Offering de-indexing as an alternative to erasure may not satisfy Article 17 obligations when the DPA determines harm is excessive. Source: GDP Rub 2. 1-1/1246-3074-22. Apt/GBA Belgium, 37/2026 Belgium's DPA, Apt/GBA. Issued a warning to an employer for deleting a video recording of a job interview after the candidate submitted an access request under Article 15 GDPR. The controller argued the recording had a short retention period for its intended purpose, reviewing the interview after the interviewer left early, and that anonymization would be disproportionate. The DPA found the controller should have retained the recording at least long enough to process the access request, violating Articles 12.2, 12.4, and 15 GDPR. Compliance action. Organizations must implement legal hold procedures that suspend normal data retention schedules when GDPR access requests are received. Deletion of data after an access request constitutes noncompliance even if the retention period would otherwise justify deletion. Source: GDP Rub 37/2026. Next section, Litigation Updates. The discoverability of artificial intelligence prompts federal district courts in the Ninth Circuit and Southern District of New York have established diverging standards for the discoverability of AI prompts and outputs in litigation. In Tremblay v. OpenAI, Inc., 2024 WL 3,748,003, N. D. Cal. Aug. 8, 2024, and Concord Music Group, Inc. v. Anthropic PBC, 2025, WL 1482734 N. D. Cal. May 23, 2025. Courts held that AI prompts written by attorneys for litigation purposes constitute opinion work product entitled to near-absolute protection. The courts reasoned that attorney-crafted prompts contain mental impressions and litigation strategy. In contrast, United States v. Hepner, No. 25 CR. 503, JSR, 2026 WL 436479 S. D. N. Y. Feb. 17, 2026. Judge Rakoff ruled that AI-generated documents created by a client and transmitted to counsel are not protected by attorney-client privilege or work product doctrine, because the act of communicating with the AI tool constitutes disclosure to a third party. The court emphasized that the AI tool used had an express provision that submissions were not confidential. AI prompts and outputs from non-legal corporate employees have also been deemed discoverable in Concord Music Group, Inc. v. Anthropic PBC, 2025, WL 2267950 N. D. Cal. Aug. 8, 2025. Compliance action. Corporate legal departments must establish written policies designating which AI tools maintain confidentiality of user inputs. Non-legal employees should route all litigation-related AI use through counsel to preserve work product protection. Organizations in the Ninth Circuit should assume AI prompts and outputs by non-legal staff are discoverable absent specific attorney involvement. Sources: Inside Class Actions. Next section, Compliance Takeaways. Implement legal hold procedures that automatically suspend data retention schedules when GDPR access, erasure, or rectification requests are received. The Belgian DPA warning confirms that deleting data after an access request violates Articles 12 and 15 even if the retention period would otherwise justify deletion. Establish incident response protocols that prioritize timely cooperation with supervisory authority investigations. Romania's Euros 2000 fine demonstrates that failure to respond to DPA information requests is itself a GDPR violation under Article 83. 5. E. Regardless of the underlying breach circumstances. Audit AI tool usage policies to identify which platforms maintain confidentiality of user inputs. Following United States v. Hepner, assume that AI-generated content created by clients or non-legal employees using consumer AI tools is discoverable and not protected by attorney-client privilege or work product doctrine. Review archived media content and marketing materials containing personal data for continued public interest justification. Estonia's erasure order against Delphi Media demonstrates that the passage of time and diminished public interest can require removal of identifying information even from previously legitimate publications. Route all litigation-related AI tool usage through corporate counsel to preserve work product protection. The Tremblay and Concord Music Group decisions establish that attorney-written prompts receive opinion work product protection, while employee-generated AI content remains discoverable. That concludes today's legal and privacy brief. From Carolina Clear Tech, for informational purposes only, not legal advice.